All rise.
Kosovo Specialist Chambers is now in session.
Please be seated.
Good afternoon, everyone, in and outside the courtroom. Madam Court Officer, can you please call the case?
Good afternoon, Your Honor. This is case KSC BC 2020-05, the Specialist Prosecutor versus Salih Mustafa.
Thank you, Madam Court Officer. Now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor, please.
Your Honour, my name is Andrew Carney, Prosecutor. With me, supporting the Specialist Prosecutor's Office are Sylvia Dascoli, Associate Prosecutor, Claire Lawson, Head of the Legal Office, and Anniko Boldog, the Case and Evidence Assistant.
Thank you very much, Mr. Prosecutor. Now I turn to the defense, please.
Good afternoon, Your Honour. Good afternoon, ladies and gentlemen. My name is Julius von Bonnet, and I am the defense counsel of Mr. Mustafa. Thank you very much.
Thank you, Mr. van Bonnet. And I note for the record that your client, Mr. Mustafa, is also present in the courtroom. Now I turn to the registry, please.
Good afternoon, Your Honour. My name is Ralph Roach, Head of Judicial Services Division.
Thank you very much, Mr. Roche. And for the record, I am Nicholas Guillou, pretrial judge for this case. On 30th September 2020, I scheduled a status conference for this Monday. I asked the parties to provide submissions of any of the items listed in the annexed agenda to my order and other topics they deemed necessary. Both the Specialist Prosecutor's Office and the defense submitted their observation this morning. The purpose of our hearing today is to review the status of the case and to organize exchanges between the parties to ensure an expeditious preparation for a trial. In particular, I wish to discuss the status of the parties' investigations, the estimated amount of documentary and testimonial evidence the parties will bring to trial, and issues related to the disclosure of supporting material to the indictment, additional material intended for use at trial, exculpatory evidence, and protected material. And finally, any other issues the parties may wish to raise. I note that the defense suggests to discuss about the course of conduct to be set out for instances where both parties approach the same witness. We will address this topic after the items already on the agenda, if you agree, Mr. von Bonnet.
Absolutely.
Thank you, Mr. van Bonnet. I also note that the defense would like to make some comments about the documents already disclosed, preferably in closed session. I invite the defense to let me know during the hearing whether a closed or maybe private session is needed. I would also like to inform the parties, and especially the defense, that the redacted version of my confirmation decision will be made available to the defense and to the public tomorrow at the latest. And in this context, I wish to inform the defense that in my confirmation decision, I set a 2-week deadline from the initial appearance for the specialist prosecutor to submit any request for protective measures in the supporting material, so any current redactions at the moment will be conditional upon my decision on protective measures. Now I invite the parties to follow the agenda set out for the status conference, starting with the section on general questions. And before I give the floor to the parties, I wish to remind them of the general principles of disclosure in the legal framework of the specialist chambers. Disclosure is an inter partes process in electronic form, organized and facilitated through the registry's court management system. Disclosure shall be a priority for the prosecution at this stage, and the parties shall disclose evidence of true relevance to the case and not the greatest volume of evidence. And in view of the publicity principle, evidence is registered as public unless there are reasons to classify otherwise. The disclosing party determines the appropriate level of classification of evidentiary items on a case-by-case basis. I would first like to hear about the prosecution on this topic of the general question. Mr. Prosecutor, you have the floor.
Your Honour, yes. Your Honour should have a copy of the prosecution submissions for this first conference, which in fact was filed with the court this morning. Your Honour, as far as the overall and general questions, Your Honour can see that as far as the issue of the investigative steps that remain ongoing in this case, there are some limited investigations to continue, and as a result of that, there is a likelihood that further evidence may well be adduced. However, the Specialist Prosecutor's Office, certainly at this stage, does not foresee that this will impact upon the speedy conduct of proceedings. And certainly the remaining investigative steps are likely to be included during this preliminary stage of the pre-trial proceedings. As far as, if I can say this, the overall size of the case, the Specialist Prosecutor's Office essentially relies upon, at this stage, 5 witnesses for the purposes of the confirmed indictment, and intends to rely upon those 5 witnesses for trial. And the Specialist Prosecutor's Office anticipates adding at least a further 11 witnesses to the witness list, although that number could vary, of course, depending on the outcome of those final investigative steps. But if I can say this, that at this stage, certainly the prosecution would be calling 16 witnesses, and there may be more, but if I can say that I wouldn't anticipate there being much more than that, and that's in order to assist the court in overall planning for the next stage. In addition to that, the Specialist Prosecutor anticipates presenting documentary evidence, which includes, for example, reports, photographs, contemporaneous KLA documents, such as orders and regulations, and other publications. So if I can indicate at this stage that that is the overall response to the general questions, and I hope that assists in giving both the court and the defence an overall idea of the scale of the prosecution case.
Thank you very much, Mr. Prosecutor. Now I turn to the defense. Mr. Fonbonnet, do you have any comments to either what Mr. Prosecutor just said, or also if you wish to contribute at this stage? I think you already mentioned in your filing this morning that it was a bit premature, but please feel free to elaborate. You have the floor.
Yes, Your Honor, thank you very much. Apart from the submissions of today of the prosecution, obviously I've also seen the redaction system that has been filed by the prosecution, as well as the comments regarding the working language. I have hardly any comments on it, only the comments that I made in my observations regarding that. As far as the investigative state or the amount of witnesses, the amount of documentary material, I can really at this point not say anything conclusively. Certainly there will be the investigation, certainly there will be witnesses, certainly there will be documentary evidence. However, the size of that remains to be seen. But let it be clear that whatever it is relevance to the case and not too much in the generalities of it. So that's my observation as far as this moment is concerned. Thank you very much, sir.
Thank you, Mr. Van Bonnet. At this stage, do you have anything to say on the potential investigations that you would like to have done for the defense, or is it too premature?
I think it's too premature, Your Honor. I have noticed that the exculpatory evidence that was mentioned in the submissions of the prosecution, I'm not 100% sure whether it was disclosure 3 or 4. I'm not 100% sure of that. But I just was wondering whether I missed disclosure 1 or that it is still to come. That is the only part that I have to say at this moment. I'm just not sure whether I missed one or not. I got 2, 3, and 4.
Thank you, Counsel. Mr. Prosecutor, do you have anything to say on this specific question of the disclosure batches?
Your Honour, yes, the disclosure 1, in fact, was the material supporting the submission to Your Honour.
Thank you, Mr. Prosecutor. Does it clarify your point, Mr. Van Bonnet?
It does not, actually. The submission to what? I haven't seen disclosure as far as evidence material in that sense. Or is it just the, what is it? The mentioning of the underlying evidence of the indictment. Is it that what is meant?
Mr. Prosecutor?
Your Honour, yes. And for clarification, the defence will be receiving in a forthcoming batch the indictment submission.
So will this be the first batch that the defense was referring to?
That's correct.
So, Mr. Van Bonnet, I think we've solved your issue. Thank you. Now let me move to the second item at the agenda of our status conference, which is the supporting material to the indictment. I would like to remind the specialist prosecutor that within 30 days from the initial appearance, all supporting material to the indictment and all statements of the accused shall be disclosed to the defense. I invite the SPO to give its submissions on the disclosure of the supporting material to the indictment. Mr. Prosecutor.
Your Honour, as far as the indictment supporting material is concerned, in fact, the defence have already received 2 batches of that material, and that is disclosures 2 and 3. And in essence, the remaining materials beyond that are in fact all witness-related materials, mostly comprising statements and testimonies. The first batches which the defence have already received primarily include non-witness related indictment supporting materials, as well as the statements obtained from the accused. But they have yet to receive the remainder of that material. And can I say that the remaining indictment supporting material primarily relates to 5 witnesses, which I've mentioned that the SPO rely upon for the purpose of the confirmed indictment. and they will in fact be the object of the specialist prosecutor's first request, a first request that we intend to make for protective measures, and that request will be filed as is prescribed within 2 weeks of the initial appearance of the accused, as has in fact been previously ordered. The witness-related indictment supporting material will, consistent with the pretrial judge's prior provisional authorization, require redaction of information that could lead to the identification of witnesses and victims, in addition to redaction of certain information falling within categories identified in the SPO's redaction observations. Such redactions are in the process of being completed, and the Specialist Prosecutor's Office expects to be ready to disclose redacted versions of the remaining supporting materials within the next 2 weeks, and in any case, and in any event, within the expiry of the 30-day period that is prescribed by the rules. I should also say that as far as that material is concerned, which includes the witness statements and the transcripts, I know Your Honour's agenda had inquired about the issue of translations into Albanian of that material. That is virtually complete, and these translations will also be disclosed within the 30-day time frame that is provided for disclosure of the indictment supporting material. As I say, there is material still to be disclosed, but that will be disclosed as I've indicated.
Thank you very much, Mr. Prosecutor. Mr. Van Bonnet, do you have anything to say on this supporting material to the indictment?
Well, Your Honour, what I've seen in the disclosures regarding the statements of my client, in those statements there is a constant reference to a particular book by a particular author, and I have not seen that book, and I'm not sure whether that book will become available or become part of the evidence. I think it's important, Your Honour, to say that, because in the questioning of my client, there has been constantly parts which have been made clear citations, and if we cannot put these citations into context, neither we can control what is the source of that particular citation. I think that is important to know, and I would like to know from the prosecutor whether the prosecutor is intending to give that and to bring that into evidence. I think that is important for the court in order to check and to test whether we are able to see what was the proper context of the citation in question, so that we can also put the proper answer of that into consideration. That is my observation. It's a question to the prosecution.
Thank you, counsel. Mr. Prosecutor, is it something that is feasible, and if so, is it feasible in the 30 days deadline?
Your Honour, my belief is that in fact the book that the defence are referring to is not contained within the indictment supporting material. However, it will be forming part of the evidence in the case, so they will be receiving that material.
Do you think it's possible that the defense receives it before the 30 days deadline?
Yes, I do.
Thank you. Mr. Van Bonnet, are you satisfied?
I take it, Your Honour, that it wasn't a book in Albanian, as I see in the transcripts that there has been constantly something translated. So I was wondering whether this is both in English and in the Albanian language available and forming part of the evidence. and whether that is, of course, feasible to do within the time limit.
Prosecutor.
Your Honour, certainly the text that is referred to is an Albanian text. Most of that text is translated into English, and that which is not translated, we will review how much more there is to translate, and certainly that will be submitted to the defence. But again, I think it's likely that the parts that are referred to within the transcripts of the accused interview, in fact, are translated and can be given to the accused.
Thank you, Mr. Prosecutor.
Yes, that does not completely satisfy the defense, Your Honor. As I say, it is already now translated, because when I read the transcript, there's a clear citation of something. However, I would like to have that particular citation seen in the context of the particular chapter, the footnotes, or whatever was the source of that particular citation. Now it looks as if there's something put to my client, and then he sometimes we can even see that he's explaining it in a different way. And therefore I think the chapters, and it does not necessarily need to be the entire book, that's why I say it's just when a particular citation is taken that we can contextualize, put it into the context and say, well, this is what that chapter was about, and that is what the particular person says, and that in that context the prosecutor took that out, that particular citation, and has put it to my client. And then sometimes I clearly see that my client says, well, probably he knows here something else is meant, or maybe that particular person describes something entirely different as far as location-wise is concerned. So I think these are really concerns that are important, and certainly when the prosecution wants to put that into evidence, I think it's very important. Moreover, the reaction of my client will certainly be a point of focus from the prosecution. So that's why I think it's very important for the defense to get that material in the proper context in order that the court can make a correct determination of the facts that the accused stated and that he has commented on. Thank you very much, Your Honor.
Thank you, Mr. Fonboni. I don't think the whole book can be considered as supporting material for the indictment. There might be some extract of it that have been used at this stage, so this has indeed to be translated to you. After that, I don't think the whole book in itself has to be translated into English. So it's a question of striking the right balance between the pages that could be relevant, and as such, this can be material that the SPO gives access to the defense, and then we will use our interpretation and translation capabilities in order to give you access to the whole material. But in any case, I think as a clarification, I don't think we shall consider this as supporting material to the indictment according to Rule 102.1a.
Yes, one more comment on that, Your Honor. In the supporting material that I've received until now, the disclosures, there is a breakdown of the UCK, or the KLA, so to speak. And I wonder what the source of that was and whether that came from that particular book or not. I took it that it was a historian that wrote that. Maybe that person is going to be heard or not. We don't know at this stage. But however, I think it is important that we know what the source was of that particular organogram or breakdown of the entire KLA. Thank you very much.
Thank you, Counsel. Mr. Prosecutor, do you have anything to add on this particular topic before we move to the next item of the agenda?
Your Honour, yes. The next item relates to the material which is additional material intended for use at trial.
Sorry, Mr. Prosecutor, just on the question of Mr. Fanboni, the specific point that he just raised, did you have anything to add on this? I think it's the organigram of the KLA, because Mr. Fanboni, if I understood you correctly, the question you had was what was the source of this document. Is it correct, Mr. Fanboni?
That's right, Your Honor, that's right.
Sorry, Mr. Prosecutor, just to clarify this before moving to the next item.
Your Honour, yes. In fact, the origin should be addressed within the metadata that the defence will have. However, if that causes the defence difficulties, then we shall address that very point inter partes.
Noted. Mr. Fanboni, can we move to the next item?
Yes, Your Honor.
Mr. Prosecutor, you have the floor for the additional material intended for use at trial.
Your Honour, yes. In addition to the material that falls under Rule 1021A, the SPO does intend to disclose, as it's obliged to, further material under Rule 1021B. We expect to be ready to disclose that additional material to the defence by the 1st of December 2020, or in any case no later than 30 days prior to the opening of the specialist prosecutor's case, subject only to any protective measures granted. The additional Rule 102B material is currently anticipated to include the statements and testimonies of at least a further 11 witnesses, and transcription and translation of those statements and testimonies remains ongoing in respect of some 8 witnesses, but of course, as the court will understand, this is a labour-intensive and time-consuming process that requires careful review and revision. With regard to the documentary evidence, the SPO anticipates presenting approximately 50 exhibits at trial, but I should add this caveat that this is a preliminary estimate and may be varied depending on the relevance of items recently seized and the results of the further limited investigative steps. Those exhibits, by way of their overall classification, are likely to include items produced by witnesses during the course of interviews, photographs, reports, contemporaneous documents, and video footage. The Rule 1021B material, that is the additional material intended for use at trial, witness-related materials, they will require redactions of those parts that identify victims and witnesses in line with Your Honour's prior provisional authorisation and or any protective measures which may be granted in addition to redaction of certain information falling within categories identified in the SPO's redaction observations. And in this regard, the SPO intends to file a second request for protective measures concerning 8 of the additional witnesses. And the SPO anticipates being in possession or being in a position to file this second request for protective measures promptly after the SPO's first application for protective measures has been litigated and ruled upon. But as I say, the date that we give as the backstop for that is the 1st of December 2020.
Thank you, Mr. Prosecutor. Mr. Fanboni, about this additional material, and especially the timeline suggested by Mr. Prosecutor.
Well, as far as the timeline is concerned, I think...
Microphone, please.
As far as the timeline is concerned, Your Honor, the the defense can agree to that, so that is fine. I am not sure whether the photo book that I've received forms part of this particular batch that we are discussing now. I was just wondering whether there was any particular material that adds explanations to these photographs that we've seen. Just simply providing a number of photos without anything that supports where we are or what it is, apart from the title, then we can't move on further. On this point, something else, Your Honor, is I've seen that in the material that is disclosed by the prosecution, they're relying in some parts on minutes of a different trial, of which I will not name at this point, but there are minutes of a different trial. And I've seen that not all those minutes have been translated into Albanian. There has been a very selective material that has been translated into Albanian. I think it's only maybe 2 statements, if I recall. But I think that is important, obviously, that if the prosecution wishes to rely on that, and if that is the content of this particular issue, then I would like to know from the prosecution how is that going to be translated, simply because otherwise we are going to rely on something that my client could not simply react to.
Thank you, counsel. Mr. Prosecutor, on these 2 questions, the photo album and the translation.
Your Honour, well, as far as the issue of the photographs, the defence have received part of the indictment supporting material and will receive the remainder of the indictment supporting material. So there is still more material to come. In addition to that, of course, the defence are still to receive all of the material subject to Rule 102(1)(b), and there will be clarity as to material that they've already received once they receive effectively the full package. Again, as far as the defence are concerned, they should understand that the material they've received is part of the indictment supporting material, and there is more by way of evidence to come. As far as the issue as opposed part of a previous trial is concerned, again, the defence will be receiving the material that is within Rule 102(1)(b), but in addition to that, which we'll come on to in a moment, the defence shall also be receiving material that's subject to 102(3), which will be detailed notice of evidence that may assist the defence in the preparation of their case. And so, again, they've only received just a part of what they're going to receive. But we note the defendant's, the defence counsel's observations, and of course we will examine those points in detail.
Thank you, Mr. Prosecutor.
Yeah, just one more thing on this, Your Honor, because parts of that particular different trial were also in the citations that were then again put to my client, and there is where he reacted to. So that is, I think it's very important that we have those parts also in Albanian translated, so that we can review and test anybody who would come forward or has something to say about that. So that part, that it is clear to the prosecutor what I'm actually aiming on.
Your Honour, in fact, it would be, again, it would be helpful if, subsequent to this hearing, if the defence were in fact to indicate to us in writing the ERN specifically of the documents that they refer to, then of course we can examine that in detail.
Thank you, Mr. Prosecutor. I think it's a good idea. Let me first say that it's just the beginning of the disclosure process. So, as you said, Mr. Prosecutor, I think you, Mr. Van Bonny, will receive the different batches that will probably answer at least some of your questions. But I think it's also important, as you said before, that on the prosecution side, you also hear what the defense needs so that you can adapt your next disclosure batch, especially on the question of translations. Unless any of the parties have anything to say on this particular topic, we're going to move to the evidence material to defense preparation, according to Rule 102.3. I would like to remind the SPO that disclosure of inspection of evidence, such as statements, documents, photograph, or tangible object material for the defense, must be disclosed without delay, and what is considered material to the preparation of the defense must be understood broadly. I also remind the parties that disputes as to the materiality of the information, as claimed by the defense, must be submitted immediately to the pretrial judge, i.e. to myself, for resolution. I took note, Mr. Prosecutor, of your submission, in which you anticipate to provide the defense with detailed notice of evidence material by 1st December 2020. Now you have the floor if you want to give more details about this, Mr. Prosecutor.
Your Honour, that is correct. The SPO anticipates providing the defence with detailed notice of evidence material to it pursuant to Article 21.6 of the law and Rule 102.3 of the rules by December the 1st of 2020. Upon the finalisation of and together with the disclosure of material falling under Rule 102.1b. The items in Rule 102.3 the notice will comprise any other residual information potentially material to the defence after the items to be presented at trial and the potential or potentially exculpatory items have been disclosed. And the SPO does expect that some of the Rule 102.3 material will require some redactions, in particular pursuant to Rule 108.1.
Thank you, Mr. Prosecutor. Mr. Van Bonny, on this specific category.
No observations, Your Honour.
Thank you. We will now move to the next item in the agenda, which is exculpatory evidence. Mr. Prosecutor, you have the floor on this.
Thank you, Your Honour. As far as the exculpatory evidence pursuant to Rule 103 material is concerned, in fact, on the 29th of September, the SPO disclosed to the defence a first batch of potentially exculpatory material. The only redactions that were provisionally applied to this material were redactions to contact details and to protect the names of investigators. We have given some detail as to the amount of documentation that has been provided already and disclosed to the defence already. I should say that that does not complete the disclosure exercise, and that the SPO is currently reviewing a second batch of potentially exculpatory material. That batch is also likely to require certain redactions, in particular pursuant to Rule 108.1. Any potentially exculpatory material identified in that material will be disclosed following review and redaction. And the SPO shall continue to review and, following application of any required redactions, immediately disclose on a rolling basis any Rule 103 material within its custody, control, or actual knowledge, as we are required to do.
Thank you, Mr. Prosecutor. Mr. Van Bonny.
The material that was disclosed on the 29th of September was disclosure 2, 3, and 4. So if that is all exculpatory evidence or potential exculpatory evidence, then I like to hear that from the prosecution. What I see is that in the first batch, those were the statements of my client, if that is what is being pointed out as the exculpatory material, or whether there is any other sources apart from that, then I would like to know that.
Thank you, counsel. If you can answer this, Mr. Prosecution, also tell us how long your review of the evidence will take.
Your Honour, that is, well, first can I just answer this, is that, again, so there is no confusion. The disclosures 2 and 3 relate to indictment supporting material. It's disclosure 4 that relates to exculpatory material, and that is that situation. As far as the other exculpatory material searches which are ongoing at the moment, we move through that as expeditiously as we can. There is a fair amount of that material for us to have to examine, and we will do so when we're able to put an exact or a more closely defined date upon that. We shall inform the court straight away. But at the moment, as I say, there is a fair amount of that material for us to examine.
Can you say anything about the type of evidence it is?
This is, Your Honour, this is a review as a result of searches conducted, which will consist of all variety of material that we have within our possession. As I say, we are conducting that review in order to be able to identify, from whatever source it is, exculpatory material that may assist the defence or undermine the prosecution, and that's the purpose of the review. So whatever the material is, if it's exculpatory, the defence will receive it.
Thank you, Mr. Prosecutor. Turn to the defence. Anything else to add?
No, Your Honour, not on this point.
Thank you, counsel. Now we'll move to the protected material. Mr. Prosecutor, you have the floor on this, bearing in mind that in your submissions you mentioned that this should not be an important issue in the disclosure process. You have the floor.
Your Honour, yes, as far as protected material is concerned, all relevant Rule 107 clearances have been obtained for material which the SPO currently anticipates tendering into evidence at trial. And such clearances as relevant have been obtained for all material which has so far been identified as falling within Rules 102.3 and Rule 103. If that should change, the SPO will promptly inform Your Honour should any further material relevant to the case be identified which falls under Rule 107 restrictions.
Thank you, Mr. Prosecutor. I turn to the defence. Do you have anything to add on this topic?
No, Your Honour.
Thank you. So now let me move to the point that the defence raised in its submission this morning, which is the course of conduct to be set out for instances where both parties approach the same witness. Mr. Van Bonnet, you have the floor on this.
Yes, Your Honour, I take it that the investigation of the prosecution is still going on, and obviously the investigation of the defence is about to start, and in that course it is maybe possible that we reach the same person at some point in time. So maybe I think it's important that no party, any of the parties, can claim or monopolize the particular witness. And even though maybe witnesses can be protected witnesses, we might get to the same one at some point. I've had that one time before in a different trial. I just want to make sure that it's in good faith that things might just occur. And then in that case, I think it's useful to have a type of course of conduct. Another part of that is also that sometimes we see that reports are revealed by a particular source that was maybe up to now unknown, or maybe that particular source couldn't speak or couldn't reveal whatever he wants to reveal or she wants to reveal. At that time, we could end up also at the same particular person for that report. So I just want to be at the beginning of the trial clear that as sometimes witnesses or experts or people who might disclose material that is hot, so to speak, then in that case I think it is important that if that person is protected, that both parties know that they're working in good faith and that they arrive at that person at the same time, or maybe one a little bit before and the other one afterwards, but that could be simply because of conducting a particular investigation that could happen. So I'm not sure whether there is any provision for that, and I just thought to bring it up and to be mindful about it, that both parties are mindful for, it's paramount for sources or witnesses, that their proper position, their own position, as well as maybe for their families is concerned, that is a paramount issue for both parties, and certainly the defense is mindful about that. We just want to make sure that as we act in good faith, we might come to this and then either submit it to a panel, we speak about it with each other, or any other kind of session that can be dealt with in order, or not, as long as we are sure that we acted in good faith, and that there would be no particular thing like things we see that people are approaching a witness, or people are approaching an expert, or people are approaching somebody has some hot information to reveal, so that there is a particular course of conduct. As far as I'm concerned, I think that in all cases, when we have a redaction system, maybe in redacted formats, when we read materials, like we do now in a particular form, we use the same pseudonym for somebody in order to get clear who it is. If we use the same pseudonym for that particular case, then it would be much easier to read the materials and to assess them. So that's why I wanted to bring it up, Your Honor, at the beginning of the trial, so that we are clear about that.
Thank you very much, Counsel. Mr. Prosecutor.
Your Honour, yes, this observation falls under the defence observation on a redaction regime, and I should say that the SPO does not envisage it impacting on the redaction regime itself. But as far as the points that counsel make are concerned, they do require consideration. And we may well make certain submissions or proposals on this very point in the context of our forthcoming and up-and-coming protective measures motions or motion.
Thank you, Mr. Prosecutor. Does it satisfy your concern, Mr. von Bonnet?
Yes, unless that happens before. But personally, I do not envisage that at this stage of the proceedings. But nevertheless, I just want to make clear that we will certainly act in good faith, and the paramount interest of the witness concerned, or the expert concerned, or whoever it is concerned that has to reveal something, is always a focus of the defense as well, in order to get the proper proceedings. But to be fair also to each party.
Thank you, Counsel. So I expect the parties to find a common course of conduct on this issue, and that there will not be any incident and everybody will act in good faith. At this point, I would like to ask the parties whether they have any other issues they would like to raise. I would also like to remind the parties to give prior notice should any submission require the disclosure of confidential information. Mr. Prosecutor.
Your Honour, no, those are our submissions on these particular issues.
Thank you, Mr. Prosecutor. To the defense.
The only other thing that I have is that I think it's maybe wise to have a calendar that we have an idea when the dates are set and for what. So that's useful.
Thank you, Counsel. I want to inform both parties that I intend to issue shortly a decision on the working languages of the proceedings. I note that the defense did not file any observation on this. Counsel, do you have any observation on this?
Working language is fine, we agreed.
Noted. Then I intend to issue a decision relating to victims' participation, in particular on issues related to the application process. And I also intend to issue a framework decision on the specialist prosecutor disclosure obligations in accordance with Rule 102, which will also set the redaction regime for the proceedings. Now I will just ask the parties for their views on a suitable date for the next status conference. It is my objective to schedule it immediately after the hearing in which the accused will enter a plea, but feel free to let me know if you have any other views on this, Mr. Prosecutor.
Your Honour, from the prosecution, no observations on that, when is convenient for the court.
Thank you. To the defense?
Yes, Your Honour. I'm not sure what the target date is for the accused to enter a plea. I'm not sure about that. As far as I'm concerned, I would have a problem a little bit with the 15th and the 20th of October. Those are dates which are a little bit unavailable.
Then we will avoid the 15th and the 20th of October. I invite the parties to make written submission if they want to raise any specific issue during the next status conference. And this concludes today's public hearing. I thank the party and the registry for their attendance. I thank the interpreters, stenographers, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned for 10 minutes, and we will continue in closed sessions for the second part of the status conference. The hearing is adjourned.
All rise.